Because it is Pride Month, we have been talking about the court cases that have given our lovely LGBTQIA plus siblings basic rights, like the right to get freaky in the privacy of their own homes. Yes, that was a thing. Right now, we're discussing the court cases and the legislation that gave them the right to get married. That was a thing too, because for a very, 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 very long time, they could not get married. And even if they could, it was only in this state and this state and maybe this state and probably that state and not that state and definitely not that state. Yeah. So, before we get to the big court case, Obergefell versus Hodges, let's talk about the Defense of Marriage Act, or DOMA. Today, the right of our LGBTQIA plus siblings to get married, it's a given, right? They have the right to get married, just like opposite sex couples have the right to get married. I mean, at least until Clarence Thomas gets his hands on substantive rights. But that's a different conversation, so we'll wait till we get there. But not so long ago, it wasn't a thing. In 1970, Jack Baker filed a suit in Minnesota after being denied a marriage license to marry another man. The Minnesota Supreme Court ruled, it was Baker versus Nelson, but they ruled that limiting marriage to opposite-sex couples did not violate the Constitution. It did. It violated the 14th Amendment. In May 1989, New York Supreme Court ruled that two gay men qualified as a family for the purposes of New York City's rent control regulations. September 1989, the State Bar Association of California urged recognition of marriages between gay people. 1993, a committee of the Evangelical Lutheran Church in America released a report asking Lutherans to consider blessing same-sex marriages. That same year in Hawaii, in Bear versus Mike, the Supreme Court of Hawaii ruled that preventing same-sex couples from obtaining marriage licenses violated the state constitution. They said it was sex discrimination. This was the case that caused panic amongst the conservative Christians across the nation. What if Hawaii legalized gay marriage? Because of the full faith and credit clause in the Constitution, all the states would have to recognize gay marriages. Oh my Lord, we can't have that. The House Judiciary Committee, their 1996 report, called for DOMA, Defense of Marriage Act, as a response to Bear, because a redefinition of marriage in Hawaii to include homosexual couples could make such couples eligible for a whole range of federal rights and benefits. And they just couldn't have that. The Defense of Marriage Act is short and sweet, but how many sentences does it take to say, this is how we define marriage, and if you insist on recognizing gay marriage, other states don't have to, right? There are 3 sections. One says, this is what the bill is. Section 2 says, no state, territory, or possession of the United States or Indian tribe shall be required to give effect to any public act, record, or judicial proceeding of any other state, territory, possession, or tribe respecting a relationship between persons of the same sex that is treated as a marriage under the laws of such other state, territory, possession, or tribe, or a right or claim arising from such relationship, saying same-sex marriages from Hawaii do not have to be recognized in Texas. Same-sex marriages from Vermont do not have to be recognized in Oklahoma. And then there's Section 3. The word marriage means only a legal union between one man and one woman, as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or a wife. Well, that one is self-explanatory. A representative from Georgia authored the bill, and one from Oklahoma introduced the bill into the Senate. And are you surprised that they were Southern congressmen? No? Yeah, neither was I. Yeah. The House Judiciary Committee stated that the act was intended by Congress to reflect and honor a collective moral judgment and to express moral disapproval of homosexuality. Moral disapproval. Mind you, homosexuality is not murder. They're not selling drugs on the playground. They're not abusing anyone, kidnapping anyone, holding them hostage, robbing a bank. They didn't colonize a nation, kidnap people from a nation, enslave them, exploit their labor, massacre them, lynch them, violate their women, and then gaslight them into thinking that it wasn't that bad. No. They just love someone of the same sex. And these congressmen want to pass moral judgment on them. Tell me, how does that make sense? Considering that they're congressmen, how many of them cheated on their wives? How many of them cheated on their taxes? How many of them, I don't know, exploited young girls, exploited young boys? How many of them took payoffs to look the other way? How many of them would go on to support treason, and they want to talk about morality? It was a Democratic president that signed it into law. Yeah, Bill Clinton. He signed it in, I think it was September 1996. And what was the impact, you ask? The General Accounting Office issued a report in 2004 identifying 1,318 federal statutory provisions classified to the United States Code in which benefits, rights, and privileges were contingent on marital status or in which marital status was a factor. Things like Social Security, housing, and food stamps, veterans benefits, including pensions and survivor benefits, taxes on income, estates, gifts, and property sales, and benefits due to federal employees, both civilian and military, were just some of the programs in which benefits, rights, and privileges were contingent on marital status or in which marital status was a factor. Under DOMA, persons in same-sex marriages were not considered married for immigration purposes. U.S. citizens and permanent residents in same-sex marriages could not petition for their spouses, nor could they be accompanied by their spouses into the U.S. on the basis of a family or employment-based visas. DOMA limited the military's ability to extend the same benefits to military personnel in same-sex marriages as their peers in opposite-sex marriages, notably health benefits. Same-sex spouses of military personnel were denied the same access to military bases, legal counseling, and housing allowances provided to different sex spouses. How anybody thought that this was constitutional is beyond me. I don't have a law degree, and I know that this was not constitutional under the 14th Amendment, and Congress should have known this, but they were too busy legislating homosexuality like it was a moral issue when it's not. Regardless, DOMA was overturned by two court cases that we will be discussing next. United States versus Windsor and Obergefell versus Hodges. Actually, we need to discuss the federal marriage amendment that they tried to pass. Like 8 times they tried to pass it. So that's coming up next, the federal marriage amendment.